That's okay.
We were working on the tribunal. Okay.
My lord, with your permission, my lord, I'll like to mention the quantum matter to be listed on.
This is the second bench tree, not before
My
this.
lord, the civil bench one was given to
No, this is the second bench tree.
second bench three.
This is bench tree. Second. Second. You have to
The-
mention before the first bench tree. Okay.
How like?
Sorry, but like to mention Article 29.
Yes.
Okay, I'm appealing on behalf of Mr. Y. Kothari. But he has some personal difficulty. As
20.
29. That would be Jinish Lalri. I'm appealing
You're
on
for the respondents.
respondent.
Inform the other side.
Yes, inform the other side. He has
80.
personal difficulty as such. I complete pay for adjournment. I pay 4 weeks time.
4 weeks will not be possible. 2 weeks time.
Much of
18 matter. Otherwise, we would have granted you. A prayer for adjournment has been made on behalf of the learned counsel appearing on behalf of the respondent on personal grounds. Full stop. Para, list after 3 weeks. List after 3 weeks. Okay, 1 more week. 3 weeks.
much of
Yes.
May I please, Your Lordship? I wish to mention item number 23, Lordship. So say I am allowed 2 weeks time to file affidavit in reply against the affidavit in opposition filed by the respondent number 4, Lord.
Item number 20.
23, Lordship.
Here for the petition.
Petition, Lordship.
On the prayer made on behalf of the petitioner, list up to 3 weeks to enable filing of rejoinder affidavit. Yes.
I didn't want for withdrawal.
This is Abdul Malik.
Yes, my lord.
Your name is not there?
Yes, my lord. I am on behalf of Mr. Asdas.
Okay. Please give your name here.
Yes,
Miss so-and-so, learned counsel appearing on instruction of Sri Asdas, learned counsel for the petitioners, submits that there are instructions from the clients to withdraw this petition. Full stop. Madam, you're for? What is your name?
P. Biswas on behalf of S.
On behalf of?
S.
P. Biswas. Ms. P. Biswas, learned counsel appearing on instruction of Sri S. Datta. Standing counsel PNRD is present. Full stop. Para. Writ petition is accordingly dismissed on withdrawal.
Right, my lord.
Item 2 and 3.
Item number 2 and 3, they relate to a disciplinary proceeding termination of service. My lord, I had a personal inconvenience. My lord, I could return back home only yesterday evening. Could it be taken up after tomorrow? I was trying to pray for today's second half, my lord, because I could not prepare the judgments only.
We'll have it on Thursday.
Thursday.
Okay, Thursday. Wednesday there may not be some time. Thursday.
Wednesday list is also come out.
Thursday, 9th.
9th.
9th. Sri R. Mazumdar, learned counsel, has prayed for a day's accommodation due to some personal inconvenience. Full stop. Para. Considering that these matters are of the year 2014, comma, list on 9/5. Sri S. Committee, huh? S. Committee, learned CGC is present. उसका ऊपर लिख दीजिए.
I'm deeply obliged.
Item 4.
Yes. Who's there?
Worship, Mintu Spakata.
Where is he?
I'm telephoning him. How does it take after some time?
It is not, sir.
Otherwise, also the thing is that we have written to personnel department also, there is one third one. That I am directed requested to examine the, in fact, we have written to education department. That I am requested to examine the matter and take needful action in consultation with the permanent personnel department as per provisions and term and conditions. In this regard, also, proper instructions are awaited from the concerned district.
No, we were on a different footing.
Sure.
His only allegations,
They are.
Are there two of
overqualified.
private respondents were overqualified.
Overqualified.
Then we ask the question, even if you interfere, what relief will you get?
Lordship.
It is not somebody coming in public interest. There is no question of any in a service related matter. But
Okay.
still then, what relief can you grant to him?
Lordship. In fact, the private respondent, he is also been made party here.
Appeared or not? Appeared. Or they have not taken steps.
Oh, then there has some, it's come for orders. So.
This matter has been listed. No, none appears for the petitioner on call. Petitioners on call, whereas Sri C.K.S. Barua, the State Council is present. Full stop. This matter has been listed under the heading inverted comma. Order, no steps. मैं बोल कर दीजिए ना. Office note dated 2/5/2024. However, reflects that no steps have been taken for service of notice upon the respondent of 6 and 7. Full stop. Para. In view of the above, comma, a further opportunity of a week is granted to the petitioners to take steps. Full stop. List on list on 13th 5/2024. Full stop. It is, however, made clear that if no steps are taken in this during this time, comma, this court would be constrained to pass appropriate orders.
Master.
Item 5. Yes,
I may be allowed on time to file reply, my lord.
17 matter, Mr.
Yes, my
Goswami.
lord. My lord, they filed the affidavit on last week only.
You had filed in April.
The copy just now.
Why do you file a affidavit of 2017 in the year 2014,
Your Worship,
2024?
I lost
7 years
contact-
you take.
I lost contact with the client. Suddenly, I
No, you lost contact with what kind of client? Who are you?
am for the private respondent.
At least 3 days may be able.
No, we'll grant you some time. We thought the affidavit was filed long time back. Dr. P.K. Goswami, learned counsel for the petitioner, prays for some time to file the rejoinder affidavit. Full stop. Para. This court has noticed that the affidavit in opposition by the respondent number 2 has been filed recently on 26/4/2024. Para. Therefore, in the interest of justice, 2 weeks' time is granted for filing rejoinder affidavit. Full stop. List on, we'll fix the date, old matter. List on 6, 1, 2. List on 22nd.
Right.
22/5. Madam Bora, you're appearing. Miss D. Bora, Standing Council Health is present.
Obliged.
Item 6.
May please the Lordship, this matter has now become infructuous.
Okay. Madam, you are not there in the record,
Yes, Lordship.
appearing on behalf of instructions.
Yes, Lordship.
Oh.
Why?
And Dekar Raja.
Yes, Lord.
And you are for?
Happy this my lord.
AP, what is your name?
W.
W?
Ahmed.
Ahmed, okay. You are a standing counsel or appearing on instruction?
I am appearing on behalf of Happy Path.
Okay. MS and Dekar Raja, learned counsel appearing on instruction of Sri Y.S. Mannan, learned counsel for the petitioner submits that the matter has become infructuous. Full stop. Para, Sri W. Ahmed, learned counsel, is present on behalf of Sri K.P. Pathak, learned standing counsel, APDCL. Full stop. Para. Writ petition is accordingly dismissed as infructuous. Mr. Das, we have recorded his name.
Must have been. My lord, it is case, my lord, petitioner served the department almost 21 years, my lord.
Which department?
Assam Rifle.
Okay.
But my lord, because of unauthorized absence, he was dismissed from service, my lord, straightway by doing summary court martial. So I, my lord, alleged some illegality and without opportunity. But today, my lord, I need 1 week time, my lord, because I want to rely on some decision of similar nature. So I want.
2017 matter, why it's been listed on a Monday, you had a weekend to prepare. Why should we give time?
My lord, only one.
And after 7 years,
2 days time, my lord. Today I could not bring, I was not well.
okay, Thursday.
Yes.
Thursday.
Unauthorized absence of 4 years and 6.
Okay, you come prepared, both of you. Thursday. Ms. S. Bora, learned counsel for the petitioner, pays for a slight accommodation, full stop. Para, considering that this matter is of the year 2017, comma, list for admission hearing on Thursday,
I'll do.
9th.
I'll do.
May please, Lord, kindly matter may be possible for timing, Lord. My senior is on late, Lord.
Yes, tax department, who's there? Income tax. Income tax department. Who appears, Mr. Roy? No, income tax, not finance. I think Mr. Kyle appears for income tax. Or any CDC appears. Who appears?
Yep.
Own counsel. IT department. Who appears, madam? Please inform Mr. Kyle also. We'll have it after some time. 17 matter. Call your senior, inform Mr. Kyle. Okay.
Oblige, Lord.
Yes.
2018 matter, Your Lordship. The matter pertains to appointment of Daura, Your Lordship. I was, Your Lordship, selected, and when my name was forwarded, suddenly after that an FIR has been lost by a relative of the candidate who has not been selected. On the basis of that FIR, Your Lordship, my appointment was withheld. Later on, that case finished, Your Lordship, I was acquitted, and I have filed my representation way back in 2018 itself to consider my case, but nothing has been done till now.
In the meantime, is the post still vacant?
My lord,
From 18 to 24, is the post still vacant? That is the foremost question you have to answer.
my lord,
If the post is vacant, there would be a scope for adjudication. If the post
But-
has been filled up, then
But-
you have to challenge the new appointment.
yes, but
Mr. Borua,
We have not received any kind of stuff from.
my lord,
these are all matters, 18 matters.
I understand that.
they're supposed to file my 2020.
At least get the instructions. Whether the post has been filled up, number one. If it is not filled up, we'll definitely adjudicate his case.
No.
He's trying to
Yeah.
make out a case.
Correct.
Which place?
Nolbari, Your Lord.
Why instructions are not there?
In fact, in regard to the representation,
Not only represent,
Yes, my
what is the status of the post? It's a
Yes.
Gaombura post. You cannot leave a post of Gaunbura vacant for years together. Maybe 6 months, 1 year, it's a different matter. Say 4 years. We are just contemplating. You might have filled up. In that case, we may not adjudicate. But if it is not filled up,
Sure.
then we'll definitely, and if it is filled up, if we can make amends to the writ petition or file a fresh, we'll adjudicate. He's trying to make out a case. He was selected, case filed to harass, and selection gone. Take the instructions. When will you have? On Monday next. Okay.
1 week. Yeah.
Okay, Monday.
Oh.
It appears, this matter pertains to the selection and appointment of Gaunbura
Gondhia Village Part 3.
in Gondhia Village, Part
Part 3.
3, in the district of Nalbari. Full stop. It is the case of the petitioner that after his selection, an FIR was lodged against him with malafide object, and for which his appointment was withheld. Full stop. Subsequently, the petitioner claims to have been acquitted or discharged.
Acquitted. I have filed the
Acquitted. Judgment was there.
Yes, sir.
Acquitted
That is on record
in the
also.
criminal case. Full stop. A criminal case, pursuant thereto. Pursuant to which he had filed a representation, which, however, has not been acted upon. Full stop. Para. C.K.S. Barua, London State Council, submits that instructions are awaited. Full stop. Para. Considering that this writ petition is of the year 2018, in the interest of justice, a week's time is granted. Full stop. List.
Lordship, Mr. Can I get 2 weeks? It's better to send this order to them, Lordship.
Send it by fax,
I
mail.
think it will take some time for this to get online.
18 matter. What online? Do you get 1 day, even a day's delay of this court? Tell us. Don't make those kind of allegations. Tell us, Mr. Barua, even if there is day's delay in an order, don't make statement like this.
That's fine.
You know what time till we stay in the court,
I know.
only to ensure
I
online.
just wanted 1 more week, Lordship. That.
Don't make all these online, this kind of submissions. Not tolerated.
I'm sorry.
If you have a problem, you tell us that this was not made online. We ensure that every order, at least orders, every day, it has to be made online. Judgment, yes, 1 day may be there may be a delay. In the interest of justice, the matter is adjourned to be listed on 15th of May. 2 more days, 15th of May, to enable the London State Council to obtain instructions.
Awesome.
All right.
Item 10 and 11.
Yes, Lordship. Currently, measurement past 48. As the engaged counsel is not present.
18 matter, madam, 18, 17 matter. Where are the counsel? This for the respondent.
I'm present. 5:30.
Okay, next Monday. A prayer for adjournment has been made on behalf of the Learned Council for the petitioner. Same order, petitioner, applicant. Order. Also considering that these are old matters, and in the interest of justice, a week's time is granted. Directing listing of these matters on Monday, 13th. Item 12.
I have entered evidence on paper, respondent number 5. I have filed with collection of petition. So, my this time is kindly granted to file. This time it was. Let's rock. Opinion of that.
This was the subject matter.
The appointment of council.
There is an appellate forum
160.
before the deputy commissioner.
No, madam. For the director of that.
Okay, oh yes.
No, Lordship, in fact, the petitioner filed appeal before the revenue commissioner, but thereafter the respondent number 5 has prepared review petition before the commissioner. And in that review petition, my lord, the order has been passed in my favor, my. In my
But
favor.
there was a change earlier from the commissioner.
Yes.
It has now been gone to the director. We had decided many cases. In fact, the last matter also perhaps it will go before the director at best, Mr. Barua. That Gaubura appointment. It will go, yes.
But it is no order has been passed. That
No,
is
then it's even better for you to contend that it will go before the director. He has to file an appeal.
when there is a order, if I'm very wrong, I think if there is a order.
No, if he is making an allegation of this nature, he can always make a complaint representation. Okay.
In this case, my lord, that the petitioner is going to.
Non appears for the petitioner on call. Whereas Sri J. Henrik Leonard, Standing Council Revenue, and Sri C.K.S. Barua, London State Council are present.
I am
Full stop.
M.H. Taluk.
Sri M.H. Chalukdar, London Council has submitted that he has recently entered appearance on behalf of the respondent number 5 and prays for some time to file affidavit in opposition. Full stop. Considering the above, as well as the fact that the writ petition is of the year 2019, 2 weeks time is granted to
Some more time, my lord.
19 matter.
No, no, I have to receive the notice only. on the
Doesn't
last
matter,
month.
doesn't matter, 19 matter, 2 weeks time enough to file affidavit, granted to Sri Talukdar, the Learned Council for the respondent number 5 to file affidavit in opposition. Yes.
Next is a lot of this writ petition maybe come with along with writ petition number 5928 of 2019.
What is the subject matter, madam?
Subject matter is that this writ petition is filed challenging the notification dated 11/7/2019 by which the respondent directed for termination of 50 numbers of Anganwadi workers who were appointed after 1/1/2016. Challenging the said notification, a bunch of writ petition is pending. So your lordship, may this writ-
Madam,
Lordship, till date, no extra copy has been served to us.
I will furnish.
Since 2019, we are with the letters.
I will
Lordship.
furnish.
if you don't furnish, then we'll dismiss your petition.
I will
You furnish during the course of the day. Miss M. Bhattacharya, learned additional senior advocate, Assam, submits that extra copies of the writ petition are yet to be served, for which instructions could not be obtained. Full stop. Para. Miss S. Roy, Learned Counsel for the petitioners, undertakes to serve extra copies of the writ petition upon the Learned State Council during the course of the day. Full stop. She also contends that there is a bunch of writ petitions, the lead case being
5928 of 2009.
5928 of 2019. On a similar, on an analogous subject. Full stop. Para. List after 2 weeks along with WPC, along with the other cases, including WPC, 59, huh? 5928.
5928 of 2009.
19, okay. Give extra copies today itself.
Make petition also. Matlab here matlab everything is complete. Petition also complete matlab. Matlab the petition.
But possible for timing, Dina to let you in.
Is for
Respond number 3 and 4.
you are not against PDCL.
This is against the PDCL and AEGCL. Post is under
It's an artist
AEGCL.
for AGCL.
Yes.
Okay, okay.
Well, in
That-
that case, matlab on Thursday, if lawsuit matlab.
Thursday we have fixed many matters. Let us try today. What's
Yes,
the-
yes.
After
Fine.
the,
Okay.
after- what is the subject matter?
Subject matter is that matlab our nine numbers of questions matlab we had dispute and we requested the authority to re-examine this 9 numbers of questions. Matlab they found out of 9, 4 numbers of correct. Matlab other these 5 numbers of questions, these answer were given as per the correct answer key. Matlab now what happens? They filed the affidavit saying that if we keep the number now, that will amount to reviewing the matlab select list. Matlab that is their claim, but they have not said these are not
Correct.
correct. So this matter is matlab also squarely covered by a Supreme Court decision.
Okay, we'll,
So that's the-
let him come. That is
My
enough.
lord. And one post already been kept vacant, my lord, in this case.
How many of you are there?
My lord, only one petition. Yes, my lord. Obliged.
Yes, madam.
But if I want to withdraw this matter as it has become infractured,
What is your name?
Pinky Kakoti.
P. Kakoti.
Yes, sir.
You're on behalf of whom? P.K.
MS
Sharma.
MSB Bhuya.
Be here. Okay. Ms. P. Kakoti, Learned Counsel, appearing on instruction of Ms. B. Bhuya, Learned Counsel for the petitioners, submits that there are instructions. And you have to want to withdraw or instruct us.
Withdraw.
There are instructions to withdraw the writ petition. Full stop. Sri C.K.S. Barua, Learned.
Alpha.
The writ petition is accordingly dismissed on withdrawal.
16.
None appears for the petitioner on call. Whereas Revenue Department, anybody?
Lordship, yes, that's
Okay.
the.
Whereas Ms. M. Bhattacharya, Learned State Council, as well as Sri J. Hendik, Learned Standing Council, Revenue Department are present, full stop. The situation was the same on the last occasion when the matter was listed on 1/5/2024. Full stop. For ready reference, comma, the said order is extracted herein below. 1/5 को put करते हैं. In view of the observations made in the earlier order, comma, this court is left with no other option but to dismiss this writ petition for want of prosecution.
And 18.
Similar matter, my lord has already decided. Same petitioner, my lord.
Yes.
My lord, I am for ALE, please for time being password matter. Because
You're an employee of the society.
Yes, my lord. Same petitioner.
Oh, same
Same
petitioner.
petitioner. Surprisingly, my lord, the both writ petition, 17 and 18, the prayer is same. Okay. The earlier petition minor has dismissed the case and subsequently they have filed and this petition.
What is the prayer here?
Lordship, kindly have a look, WPP 2021,
No, there are
prayer
two.
6, page number 6, the prayer portion is there. Page 6 matter. Mandamus cannot be issued by allowing the petitioner to serve as the secretary of the Bhaktapara Samabhai Committee under Dhula Police Station, so and so.
But this is a separate cause of action.
Then 628, my lord. WPC number. Page 8.
Page 8.
8. Rita Mandamus shall not be issued by allowing the petitioner to serve as the secretary of Bhaktapara Samabhai Committee under Dhula Police Station. So both the petition prayer is there.
Why
Like-
two writ petitions? Why two writ petitions?
And he is the employee of a society, my lord. So read the fact.
What is your name?
My name or A Sharma, or
On behalf of
ALE.
Hard Sri A. Sharma Learned Counsel for the petitioner who appearing, A. Sharma, Learned Counsel appearing on behalf of Sri A. Ali, Learned Counsel for the petitioner. Full stop. Both the writ petitions filed by the same petitioner are more or less on the same subject. Full stop. While in the first writ petition, WPC 20 of 2021, there is an additional prayer to set aside the appointment of the private respondent as the secretary of the Bhaktapara Samabhai Samiti under Dhula Police Station in the district of Darang, the no, 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 no. क्या लिखा? The no, in the first represent the पहले क्या लिखा? Additional paragraph नाम लिखे. Both the writ petitions have challenged, have been filed with a prayer, to set aside जो पहले लिखा, Para. Be that as it may, Miss M.D. Bora, Learned Standing Counsel Cooperation Department, has, however, submitted that the same petitioner had subsequently filed WPC 3568 of 2023 with a prayer for release of salaries, full stop. This This court, however, had disposed of the said writ petition vide and ordered it at 29/9/2023 by holding that do the society can be construed, now would be a body corporate under the Assam Cooperative Societies Act, 2007, that by itself would not bring in a dispute for release of salaries in their case from the society within the ambit of the writ jurisdiction of this court, full stop. This court had also made an observation that no opinion on merits of the respective parties was expressed, full stop. Para. The learned council, standing council has submitted that the petitioner is not an employee of the department, but was privately employed by the society. And therefore, the present writ petitions would not be maintainable. Full stop. Para. Following the analogy laid down by this court in the order dated 29/9/2023 in WPC 3568 of 2023, this court is of the opinion that the same would also apply for the present two cases, which incidentally have been filed with the same cause of action. Full stop. Para. Accordingly, both the writ petitions are dismissed on the ground that the dispute raised may not come within the ambit of a dispute amenable to the writ jurisdiction of this court. Full stop. The writ petitions are accordingly dismissed. Full stop. However, no opinion has been expressed by this court on the merits, on the inter se merits of the rival parties. Full stop. पहला केस जो था dismissed on withdrawal होगा. हाँ, एक लाइन देगा. पहला केस था cited as so and so. क्या लिखा उसमें? Miss so and so has submitted earlier on 3/5/6/8/2023. No, before that, Miss, before that, 3/5/6/8, we have mentioned 3/5/6/8. First time when you have before that, पीछे नहीं आगे. Then MD बोला था. Then हाँ, डिलीवरीज में हाँ dispose of it. This court, however, dismissed the said writ petition. ठीक है, अब देख लेते हैं. Okay.
Liberty may be given to them to approach the.
Liberty is there.
Mark.
It is needless to state that the petitioner would be at liberty to approach the appropriate forum for redressal of his grievance.
Deeply obliged.
In this case, we were directed to file an affidavit, Your Lordship. Lordship, with the affidavit we just received today, your lordship, but some voluminous annexes need to be annexed, your lordship. So some time may be granted for us to complete the filing.
What is the matter, madam?
Lordship, in this case,
Lordship,
Two petitioners,
yes, your
two
lordship.
separate petitions,
Yes, your lordship.
What-
Lordship may take up item number 20,
28,
20,
uh,
477.
477, yes.
Yes, sir.
You just tell us in brief what is the subject matter involved?
Lordship, in this case, the petitioner, she was, the matter it pertains to the promotion of the Anganwadi worker to the post of supervisor, Lordship.
Okay,
Lordship, we are challenging the promotion of the respondent number 5 on the ground that the respondent number 5, she had obtained 58 marks. And the petitioner, she has got 69.33 marks.
secured more marks.
Yes, your lordship.
Then
Lordship, their contention is that the respondent number 5,
is an OBC
being
candidate.
an OBC candidate, is entitled.
Are
to
you
the-
disputing her status?
Yes, your lordship, she herself has stated that she is a general category lord.
Unreserved category.
Yes, your lordship.
that is why we have taken some time to find out if she is indeed some OBC is there or something. Not,
Oh.
we have also found out to be she is a general category candidate, your lordship. But your lordship, one issue still remains, your lordship. She is an OBC category candidate. She was treated as an OBC category candidate and she got lesser marks. They are general category admittedly, your lordship. Now the issue that has happened is that the cutoff mark for general category is 71.
Hmm.
Now she got lesser marks because she was treated as an OBC. So whatever may happen to her, that's a separate issue. The private
They may
response
not
is
get the
separate.
relief.
They will still not get it because the general category cutoff is 71 year old.
You got 69
69
and the other one
69.33 year
almost similar.
similar.
Both of you are challenging the same.
Respondent number
Okay.
5, your
Mr. Ratta, for the,
Yes, sir.
you are an unreserved.
No, I don't claim to be OBC. I never claimed to be OBC.
Okay.
There's another point, Milord, this delayed by about 6 years.
And this is
Delayed by about 6 years.
Delayed.
Delay, man.
and this is effectively illustrated harmed us, prejudice us, because what has happened is that we have a memorandum of understanding with a third party to conduct the written examination, and they were supposed to keep the record for only 3 years. So now, because of that, certain records is also not available with us, so we cannot come before the court with a full records also, your lord. So that is one another issue, because they approached only in 2000.
What is the, how have you explained the delay, madam?
Lordship, delay has been explained in paragraph number 18 of the.
Now, how? You need not, you need not read the pleadings, but how
yes.
have you explained?
Lordship, one of the Lordship, one of the applicant of this had filed an RTI application in the year Lordship 2009, 2016 year Lordship,
When was the selection made?
2016 itself.
16
Lordship.
you filed an
Because your
RTI.
Lordship result was not published, your Lordship. So one of the applicant has made an RTI application, and then it came to view that the respondent number 5, he had obtained 58 marks.
When was the result of the RTI received by you?
No, Lordship, I made an RTI application on in the year 2019, Lordship. After coming to know about the result of the respondent.
First, you may not get any relief. Number one, which is very important for us. The private respondent no doubt has got the benefit of some anomalies, but and you can make out a case, but will you get anything?
Lordship, let them file an affidavit.
No, well, he has admitted, Mr. Hazarika has said in fact, Mr. Dutta has also admitted,
Yes, your Lord.
she belongs to unreserved, got a benefit.
Lordship,
But temporary or interfering with that, will it benefit any one of you?
Lordship,
Neither to you nor to the respondent of.
Lordship,
Normally, we would have.
Lordship, in the meantime, my mother-in-law also expired in 2019.
19.
19. the
19,
COVID
16 to
situation.
19.
Lordship, when COVID came, then
16 to
immediately after
19.
COVID-
We are not on COVID. COVID came in 20.
Yes, your
March.
Lordship, immediately
16
after
to
COVID, we
20.
have filed the writ
16 to 20, what do you do?
Lordship, in the year 2016, Lordship, if one of the candidate of the selection process, she had applied, she had made an RTI application because results were not published. Thereafter, I have come to know about the reply of the RTI application. Then in the year 2019, I made,
Results were published when?
Lordship, I'm not
16 year
aware.
16 appointment made when? 16.
The promotional matters, not the fresh appointment in the department.
You were in the department as an Anganwadi worker, you knew that private respondent is working as a supervisor. COVID came in March 2020. Yes, 6 months, 1 year delay may be there, but, and most foremost, you may not get any relief. At times, even if you make out a case, we may not like to interfere if it is not effective for anybody. And rather it might disturb the system. Somebody is working. Let us see. You put the affidavit on record.
Actually, date may be fixed.
We'll fix it. Friday?
Monday, next Monday.
Next Monday. Okay. Third, Ms. P. Hazarika, Learned Counsel for the petitioners who have put to challenge the promotion of the private respondent as supervisor in the in which project?
Lordship, it's South Karimganj ICDS project.
In the South Karimganj ICDS project. Full stop. Para, Ms. Sri C.S. Hazarika, Learned State Council, however, submits that the affidavit in opposition is ready and would be filed shortly. Full stop. Sri M. Datta, Learned Counsel is present for the private respondent. Full stop. Para. Considering the subject matter, comma, list this case on Monday, huh? 13th? 13/5/2024, on which date an endeavor would be made to dispose of the writ petitions. Do hai, huh? Duta.
Republic.
You have filed affidavit otherwise.
Yes,
for that,
I have.
okay.
I have.
Try to bring some cases that if
have
no
already
relief
put-
can be
I
granted,
have already-
uh,
I have
it may not be very prudent to interfere.
I've got.
Okay. Mr. Taxman,
What if in this brief is not with me? Gogoi
you are not the taxman.
I can access to
Last
my-
occasion, Dr. Gogoi appeared and took that.
Okay.
Now here, to my friend, I have come to earlier, my
Is
friend
he
appeared.
appearing? Dr. Gogoi is appearing
He's
otherwise.
He's the junior counsel in the.
Income tax
He
department.
appears otherwise.
Yes,
His name
Okay.
soon. That's
Okay.
why-
No, is he there today in the court?
I didn't find him. He rang me, he said he maybe has got some problem.
Okay, then we'll have some other day.
Any date, my lord,
Day after tomorrow?
I will inform him.
Or day after tomorrow, it may not be possible.
No, the two, Friday?
Thursday, we have already fixed matters. On Friday.
Obliged.
His name is otherwise appearing?
Yes, yes.
His name is-
Please inform Mr. Dr.
I will also
Okay.
inform him, ma'am.
Mr. Kyle can inform. Okay. Heard Sri S.C. Biswas, Learned Counsel for the petitioner. Which matter?
I can wait.
Para. Sri S.C. Kyle, Learned Counsel, who also appears for the Income Tax Department, has however submitted that this matter has been entrusted to Dr. B. N. Gogoi, who, however, is not present in the court today due to some personal inconvenience. Full stop. Para. In the interest of justice, list on Friday, 10/5/2024. What is the issue?
Well, issue is that an employee of income tax department was missing long ago.
Okay.
And her husband, his husband has filed this case that I should get the benefit of.
Oh, it has nothing to do with tax.
Yes.
No.
It's a service-related matter.
Yes. Now the main question is that,
The
There was no-
the employee he has gone missing.
yes, but there was no FIR from the department nor by the
Where
wife.
was he working?
Income tax department.
Where?
At Guwahati, Group D.
Okay, then he went missing.
Yes.
Wife has come here.
Wife has come here after long, 32 years. And that's so through legal aid.
Oh, you're through legal aid.
Yes, yes, I am bearing the expenses of everything.
In the
If I can do something to her, she is a helping hand in the house to house matter.
But I've seen this case that after 32 years she has come. The matter was raised by the court, honorable court also. But court is still sympathetic if anything could be done legally.
What post was your husband?
Group D, my lord.
Group D?
Yes.
You haven't got anything?
No.
How long did he serve?
He served for, after appointment on the compassionate ground, he served about a year.
Then missing.
I don't know what happened, but
I have not seen the affidavit. The stand has been taken by the department that disciplinary proceeding was there. That was proceeded ex parte.
He was missing.
He was dismissed from service.
No, he was missing. How can you dismiss a missing person or a dead
No,
person?
actually, I'm not aware.
No.
because
There are many cases where persons are presumed to be dead and you dismiss him.
yes, my lord.
But that is without going to the record.
No, perhaps we can balance something or whatever can be possible.
Or I'll talk
Some
to the
benefit. You talk to Dr. Gogoi as well as the
officer.
department.
No.
Yes. Anything lump sum for her sustenance, or at least she can live a dignified life. Okay.
No problem.
So the petitioner is claiming pay parity. His colleague, my lord, he was appointed as constable tradesman in the year 1992. The CRPF.
Mr. Roy Reddy?
They have not filed a reply, lord.
Doesn't matter. Yes.
But on 23/7/1992, the petitioner was appointed as constable tradesman. to
How many
dri-
petitioner?
One.
One petitioner.
One.
Appointed as
Constable tradesman, also a driver.
tradesman.
Tradesman.
What do you do?
Well, I'm a driver. Stroke driver. His designation is CT stroke driver.
Okay.
And in the year 2004, that is on 11/10/2004, he was promoted to the rank of head constable stroke driver.
Yes.
The problem arose if your lordship would kindly come to Annexure 1, page 16, Annexure 1 series.
Hmm.
Here, my lord,
Page
my
16.
page 16 is the type portion. Even the page 17 that can be understood.
Yes,
the
yes.
clear page. My name is Shivraj Singh. The very top lordship will see name Shivraj Singh.
Yes.
Designation HC head constable
Head
driver.
driver, yes.
And my basic pay, the first basic pay is 41,600.
Yes.
Now my juniors, even their pay slips I have annexed from page 18 to 21. All of them are head constable driver, but their basic pay is 42,800.
Where?
I know at the very next page. About 4 of my juniors I have annexed the pay slip. This is Joy Prakash Sharma. Basic pay, designation is same. Head constable driver. Basic pay is 42,800.
Okay.
There lies the difference. Now,
Is there any difference in your induction in the service?
Sorry.
Is there any difference in the method,
These
in
are-
the
these are
time or
these are
manner of induction?
These juniors are direct recruitees, and I was promoted. Now I'll bring your lordship to the very next annexure, that is the office memorandum, which clarifies this. This is by under orders of the president. Annexure 2.
No, irrespective of how we have entered into the service, you should get the same benefit, same pay. And unless there is a time gap, maybe by the time they had entered, the pay scale was different.
All the 4 or 5 annexures which I will show you for your lordship. The only thing, and even today in their affidavit, they say clarification is required. Office office memorandum is there.
What
It
is the OM, what is
My
the
lord,
OM?
page 22, my lord.
Two, two.
2. I'll take your lordship to the relevant portion. It starts
22,
at page 22. This is 28th of September
Yes.
2018
yes.
by the Ministry of Finance, Department of Expenditure. Para 8 at page 24, my lord. That is the relevant part.
Para?
Para 8 at page 24.
Yes, please.
Page 24, para 8, if I may read that. Accordingly, the President is pleased to decide that in respect of those posts where entry pay of direct recruits appointed on or after 1/1/2006 as per section 2 of part A of the financial schedule of CCS RP rules 2008 becomes applicable by virtue of the provision of the element of direct recruitment in the relevant recruitment rules. The pay of central government employees who were appointed to such posts prior to 1/1/2006 and whose pay as fixed in a revised pay structure under Rule 7 thereof, as on 1/1/2006, turns out to be lower than the prescribed entry pay for direct recruits of that post, shall not be less than such entry pay with effect of 1/1/2000.
Hmm.
So they have clarified that I should get 42,800 instead of 41. Now, the DIG admin of CRPF at Annexure 3, my lord, page 25, taking note of this particular OM of 20th September 2018, page 25, the DIG admin, he writes to all headquarters at serial number 3 of page 25, my lord. In order to implement the above order, the following directions are hereby issued. All head of offices, TDOs, shall apprise above provisions to all personnel working under their command and ensure that no affected personnel are left out from the above benefit, if otherwise ineligible, in a time-bound manner. Now, the direction was given to them, but they kept on failing, saying that clarification regarding head constable or driver, that particular post has not been clarified. They keep on saying that the post of inspector, those have been clarified that you should get the benefit, but no clarification has been received from the ministry. However, I will not take your lordship to the other annexures. The last clarification from the ministry, ma'am. This is Annexure 7.
Page?
Page 30. Central Civil Revised Pay Rules 2008, Section 2 of Part A of the first schedule thereto, entry pay for direct recruits appointed on or after 1/1/2006 and pay fixation in the case of personnel other than direct recruits. Reference this signal so and so, dated so and so, which it has been desired not to allow such benefits to the CRPF employees until and unless the decision on our proposal in respect of inspectors GT of this DTE is received from Ministry of Home Affairs, Ministry of Finance. After protracted correspondence and due justification on different pleas given to the MHA by the DTE from time to time, this is to inform that now the Government of India, Ministry of Finance, Department of Expenditure, via their letter number so and so dated 30/3/21, has finally agreed and accepted our plea proposal that the pay of promotee inspectors GT of CRPF on the date of their promotion should not be less than the entry pay of Inspector GD. Sarvesh Tomar appointed directly in CRPF as Inspector GD on 18/10/2006 in the pay scale of so and so in the Department of Expenditure. Further, the Finance Directorate has also accorded necessary concurrence for allowing such benefits to CRPF employees on 29/7/21. In view of the above development, it is stated that all such pay-related matters which fulfill the conditions as per OM dated 28/9/2018, that particular OM matter, may be allowed. Besides the above, this directorate signal, if it is treated as withdrawn, cancelled, as the decision of government directorate of expenditure has now been received in favor of CRPF employees. Now they even in their with all these annexures, they have annexed matter. They keep on saying that further clarification is required. Until date, matter, I have
Only for the instruction today, that lordship, this is for only for the inspector GTN. They are not entitled.
the
because they
second
are-
line is quite clear, matter.
Now, how do you differentiate between the service
Lordship,
vis-a-vis the pay scale?
vis-a-vis the pay scale lordship, they are the direct recruit. And
Now, if you are giving the promotee in the rank of inspector,
lordship,
the pay parity, so far as the direct recruitment is concerned,
yes. As
how do
per
you
MHA,
differentiate the services
lordship,
of a head
this is, lordship,
constable?
only, I'm waiting for that instruction that it was not given to me till today, lordship. Why this are not given? Because earlier it was given, then it has been withdrawn, lord. Because they are not the direct recruit.
Now, that we have understood. He has never claimed to be a direct recruit.
No.
Initial appointment was a constable tradesman /
Yes.
driver in the year 1992, promoted in 2004 as constable driver. Now, can it be contemplated that a promotee would get a lesser pay in the same post than a direct recruit?
Lordship, lordship, my submission.
Won't that be unfair, grossly unfair?
Lordship,
You are discharging the same duties,
lordship,
same
they are
post.
Havaldar, they are not the inspectors, lord.
We are not on the rank of inspector, we are on the rank of
And immediate-
constable, head constable,
Because-
driver.
If lordship it was given, it will financially repercussion with.
If it happens, it happens. How do you treat two persons doing the same job? One has been directly recruited, one has been promoted. If the matter had been different, that the direct recruits were serving for a long period of time, they got an increment. But that's a different matter. Here is the basic pay. The basic.
Basic, lordship, but for that, give me some time, lordship.
No, no.
because
These are not matters where time is to be granted. Heard. Sri P. Bharadwaj, Learned Counsel for the petitioner. Also heard Sri S. S. Roy, Learned CGC,
Right.
appearing for all the respondents, who has also filed affidavit in opposition on 9/9/2022. Full stop. The issue is towards a claim for parity in pay. Para. As per the facts projected, the petitioner was appointed as a constable tradesman / driver in the CRPF on 23/7/1992. Full stop. After serving in the said capacity, after about 12 years, in the year 2004, the petitioner was promoted to the rank of head constable / driver. Full stop. The grievance of the petitioner is with regard to the basic pay. Full stop. While the petitioner is receiving his pay on the calculation of his basic pay as 41,600, for the other similarly situated head constable / driver, the basic pay is rupees 42,800. Full stop. Para. Sri Bharadwaj, the Learned Counsel for the petitioner, has submitted that all such persons who are similarly situated, qua the nature of posting and service, are however junior to the petitioner, and full stop. He, however, admits that such persons are direct recruits, whereas the petitioner is a promotee. Full stop. Para. The Learned Council has also placed reliance on an office memorandum dated 28/9/2018 and a further communication dated 29/11/2018 by the DIG admin pursuant to the aforesaid office memorandum. Full stop. The Learned Council points out that there is a clarification in the communication dated 29/11/2018 that no persons are to be left out. Full stop. The Learned Council accordingly submits that necessary directions are to be issued for giving the emoluments of the petitioner with the basic pay as rupees 42,800, which is at par with the other persons serving as head constable / driver in the organization. Full stop. Para. Sri Roy, the learned CGC, on the other hand, has submitted that the claim of the petitioner may not be admissible inasmuch as the office memorandum dated 28/9/2018 as well as the letter dated 29/11/2018 pertains to the rank of inspector, correct?
Yes, sir.
Inspector.
Chief.
Inspector and
Inspector / Chief. General duty, Inspector General duty.
Inspector General duty. Full stop. The learned CGC submits that unless there is an explicit instruction for grant of an equal basic pay so far as the post of head constable is concerned, such OM or communication cannot be automatically be held to be applicable. Full stop. The Learned Council for the department has also submitted that the persons who are getting the basic pay on a higher rate are direct recruits, whereas the petitioner is a promotee and there is a change in the mode of entry in the service.
There is no direct recruitment for that. No.
And there is a change, no, there is a difference in the mode of entry, not change, there is a difference. Para. The private contentions have been duly considered. Full stop. It is not in dispute that the emoluments given to the petitioner is calculated on a basic pay of rupees 41,600, whereas for the other direct recruits who are also junior to the petitioner, their emoluments are calculated with the basic pay at rupees 42,800. Full stop. The office memorandum dated 28/9/2018 would have an immense bearing in the adjudication of the present claim, and accordingly, the relevant part is extracted here and below. Page 24. Paragraph 8. Full stop. Para. The said office memorandum has further been clarified by the communication dated 29/11/2018 for its proper implementation with a further instruction that no persons are to be left out from the said benefit. Full stop. The objection raised for denial of the said benefit is that such benefit is that the office memorandum in question only covers the post of constable, post of inspector GD, and therefore the same cannot be extended to the post of head constable, oblique driver, full stop. The claim of an incumbent who holds the same post with some others for getting the same basic pay cannot be held to be an unreasonable claim. Full stop. On the contrary, this court is of the opinion that considering that there is no dispute in the equality of the post oblique rank and the nature of duties performed, the payment of basic pay would not at all be dependent on the mode of entry into the said post, that is, whether such post was entered into by way of promotion or by direct recruitment. Full stop. This court is also of the view that the office memorandum dated 28/9/2018, though only stipulates the post of inspector GD cannot be restricted to the said post, as such clarification would be applicable for other posts as well. Full stop. Para, in view of the aforesaid discussion, this court is of the opinion that a case for interference is made out. Full stop. Accordingly, the writ petition stands allowed by directing payment of the emoluments of the petitioner by taking his basic pay as rupees 42,800, which is at par with the other persons in the same post of head constable, oblique driver. Full stop. The petitioner, such benefit has to be given from the date when the office memorandum dated 28/9/2018 was implemented. Full stop. Writ petition accordingly stands allowed.
Interest.
No, not interest.
Okay.
My lord, here the readings are complete. Can we fix for hearing?
We have fixed for hearing today.
Please for admission.
Admission hearing, clarifying.
My lord, this matter is on the additional reservation given to SC/ST, my lord, on the basis of presidential directive. But realizing the mistake, Oil India has once again tweaked their policy and said that the additional concession which is given, that would be in addition to the selectivity ratio which is applied in the matter of promotion. So, my lord, we have changed the pleadings, my lord. My lord, I have seen in their affidavit, my lord.
What is your claim?
My claim, my lord, is that I belong to the unreserved category. I was within that 70%, but I have been removed
to accommodate persons from the SC and ST. So therefore, what I am claiming, my lord, is that this concession which is given to the scheduled castes and scheduled tribes should be in addition to that. And persons who are within the selectivity ratio, they should not be removed to accommodate, which they have corrected in the subsequent policy decision taken in 2021.
Now your correction was when?
I was entitled, my lord, with effect from 1st of January 2021, but I had been given from 1st of January 2022. So my claim, my lord, is that I should be given the promotion with effect from 1st of January 2021, not 1 year later, because I am within that 70% selectivity. That is on merit.
Yes, Ms. Chaudhary, what you say?
My lord, the policy which is applicable when the promotion of the pensioner was concerned, we have followed that, and as for that policy, he cannot leave from that period. And maybe my lord, subsequently the policy has been modified, but he'll be governed by the policy as existing on the date when his
Date of consideration. Are you trying to get a retrospective benefit of a policy change in policy?
No, my. In fact, before that policy changed, my lord, I had preferred the appeal side. And that policy changed, my lord. It is the concession given is on the basis of a presidential directive. There is no change in the presidential directive. Therefore, my lord, if they are making any change in the policy in matter of reservation, there has to be a fundamental change in the matter relating to reservations. There is no such fundamental change.
What is the change they are trying to bring?
They have given, if my lord comes to, my lord, the policy, my lord, at page 69.
Yes.
My lord sees the table under 2.6, composition of TPC.
Yes.
Just the note just below that table, immediately below, concessions to SCs and STs in posts to be filled by promotion by selection will be regulated by DPE OM so-and-so dated 31/1/2014 or as amended from time to time. This concession will be in addition to the selectivity ratio. That's the second sentence of this, my lord, that this concession will be in addition to the selectivity ratio. This is what they have brought in the change in 2021. My lord, when my promotion was considered, this particular sentence was not there. So what they have done is that they have removed me from the 70% selectivity ratio and accommodated the scheduled tribe and scheduled caste candidates. What my claim, my lord, is
this concession,
my lord,
will be in addition to the selectivity ratio.
The selectivity ratio is 70:30, 70 by merit and 30 the
And this page 69 is of what date?
This is of 2021. And it starts from page 60, my lord.
No, that is okay. What date is of 2021?
2021. This is as on 18/11/2021 at page 60, lord.
Relation to the
And my promotion was
where is this letter of 31/1/2014?
Mild.
Page?
Mild. Page 107, mild.
107. Yes.
The undersigned is directed to refer to the Department of Public Enterprises OM of even number dated 8 November 2004 on the subject matter mentioned above, and to say that consequent upon implementation of the 6th Pay Commission recommendations, DOPT has issued OM so-and-so dated 7 June 2013, stating that the new ceiling for concessions in case of central government employees would be carrying a grade pay of 8,700 or less. Since no equivalence can be established between CTA scales and IDA scales, more so because many scales have been merged into four bands under CDA pattern. The earlier identified, earlier grade identified in 2004 for CPSC employees, that is E5, may continue to be the reference post for the purpose of implementation of concessions to SC/ST employees, administrative departments, so and so. my lord, previous to that, at page 105, my lord, is the 2004. Or just before that, if my lord comes to 102, my. This is of 1991, my lord. My lord may come to page 103, para 14.
Now, how has it prejudicially affected you?
My lord,
You say that you are within the 70%.
I am within this.
Then
I ought to
this is
have been,
only with the on the aspect of parity of which pattern they would follow, CD or IGA.
they follow the.
No, the 107 is only
My-
with regard to the pattern.
My lord, this is the subsequent one, though they have mentioned this.
Now, what is the prejudice you have
My lord,
suffered?
my prejudice,
And
my lord,
how?
my lord, because the promotion scheme, my lord, it says 70, the selectivity ratio, that is 70:30. Those who are within that 70% on merit, they get promoted on completion of 5 years. The
You
remain-
are an unreserved category.
I mean,
You belong to the 70%.
I belong to the 70%.
Okay.
And the remaining 30, my lord, they
Yes.
get promoted on completion of 6 years.
Petitioner unreserved
Unreserved,
within 70%.
within 7.
What is your criteria? Five years.
5 or 6. For 70%, it's 5 years.
5 years. 5 years is the period for which you should serve in the feeder post.
In the figure again.
Okay, service. Then for 30%,
It is 6 years.
reserved is 30%.
No, my lord. This is this concession is in addition to it, my. The reservation is in addition. Those who are within 70%, they'll get promoted on completion of 5 years.
Okay.
The remaining 30% on
Yes.
completion of 6 years. Now,
6 years.
6 years.
We have not understood this.
My lord.
properly.
My lord, there is an APAR score, the performance review. They give some weighted performance and the qualifications, everything is taken into consideration. On merit, the overall merit is considered. Those who fall within 70%, if there are 100 persons, 70 persons who are in the higher merit category, they will get promoted on completion of
5 years.
And the remaining from
Okay.
71.
Now I have understood.
Yes,
Okay.
Now,
It's not a division.
it is not a.
Just like that. You select 70% of the candidates on basis of the merits.
Merit.
Who qualify within the 70%,
Yeah.
their completion of 5 years is the standard for giving them promotion.
My lord.
If you do not compete within the 70% and
Then-
comes to the rest 30%, then you have to complete
On 6 years.
6 years. Okay. And then this is nothing to do with the reservation.
Nothing to do with
Yes,
it.
yes.
The reservation comes, my lord. There is a presidential directive that says, if my lord comes to page 103,
Yes. Yes.
my lord, para 14, promotion
103.
103,
Yes.
para 14,
Mm.
so the last line of this.
Yes.
Para 14.1 here, my lord.
Yes.
In promotion by selection to posts within Group A, Class 1,
Mm.
which carry an ultimate salary of rupees 2,250 revised to 5,700 per month or less, there is no reservation, except a concession, namely that the scheduled caste, scheduled tribe officers who are senior enough in the zone of consideration for promotion so as to be within the number of vacancies for which the select list has to be drawn up, would be included in the list, provided that they would, provided that they are not considered unfit for promotion. Their position in the select list would, however, be the same as assigned to them by the Department Promotion Committee on the basis of their record of service. They would not be given for this purpose one grading higher than the grading otherwise assignable to them on the basis of their record. It may be noted that the salary limit of 2,250 per month mentioned above has been revised to 5,700 on the basis of the High Power Committee. So
Okay.
this is thereafter, this was increased, my lord, page 105. This was in 2004. The same directive is incorporated in 2004, 105, but the salary limit has been increased from 5,700 to 18,300. The 2014, which they are referring to, my lord, is.
No, you have not been able to pinpoint your problem.
My lord.
You say that you score the APR marks and come within the 70%.
My lord.
So after 5 years,
My lord.
you should have been
I
promoted.
should have been promoted.
Now you have not been promoted.
I have not
Why?
been promoted. My lord, they have misapplied this presidential directive. They say that to accommodate the SC/ST candidates, they'll remove the equal number from within the 70% and promote the SCs and STs. That is how I've been,
Whether they fulfill the minimum APR or not.
irrespective of that, but they should be within the zone of consideration. If they are within the zone of consideration, even though they may be in the 30%, they will be promoted.
So ultimately you come to the next 30%
I
or
come-
6 years.
Yes, my lord. So now they have corrected. This was an anomaly which they had been practicing. They have corrected that in 2021.
Mr. Chaudhary, if you have corrected, why don't you give the benefit?
My lord, we have to abide by the policy which was enforced at the time of consideration of the promotion. Before coming to that, my lord, may I take your lordship to the prayers made in the request? Page 33.
Yes.
A written in nature of Benjamin or India so and so directing the respondents to promote the petitioner from grade C to grade D with effect from 1/1/2021. Prayer B, directing the respondents to forthwith pay the petitioner the consequential salary and fix his pay. So, my lord, these are the two prayers. Now, the other persons have been promoted, they have been made, my lord, respondents in the writ petition.
Okay.
Their promotions are not on the check. So, my lord, in the event, my lord, the petitioner is to be allowed, my lord, one has to, at least one person has to, my lord, be out of the promotion. So that prayer has not been made. Further, my lord, the 2006 policy decision, which is, my lord, which is to his prejudice according to him, that is not attested. Therefore, my lord, the relief cannot be granted. And in any case, my lord, we have, we're bound to, my lord, abide by the policy decision of 2016, and that is what.
Is there any clause in the, when the change was incorporated,
Right.
that would be given effect retrospectively or?
No, it was not.
Okay.
My lord, here.
If your lordship kindly,
If
relevant clauses, your lordship will find, my lord, at the 53. In fact, my lord,
is this the lone challenge or are there challenges of the present nature?
Yes.
Is this the lone challenge or are there
yes, my
challenges?
lord. In fact, there is no other. Everyone has accepted it. There has not been any instance heard here. And he was, my lord.
See, if Mr. Nair, if you can make out a case that so far as the policy existing at the time is concerned, there were some anomalies, but if the anomaly which you're trying to now raise is based on a subsequent correction, that correction, if it doesn't give a retrospective effect, can you open it, reopen it?
My lord, the policy nowhere says that those persons in the selectivity ratio within that 70% would be removed to accommodate SCs and STs. When they misapplied this policy in my case, I preferred appeals, departmental appeals. Thereafter, they issued this further note. They did not change the policy. The presidential directive remains the same. If that is the same, my lord, how can they incorporate another reservation policy? It is based on the same presidential directive. In the previous policy of 2006, my lord, there was no mention.
Mr. Kyle, for whom? Chen cannot be removed now. He's already been removed. Voluntarily removed. Okay, I will decide on some other day then.
My lord.
We thought it was a very urgent kind of a matter. Whenever, tell us.
Thursday.
Thursday, many matters, no, not.
My lord. I thought the 14th of it, attached.
Part three, meeting Ireland Council for the petitioner. First up, the IOC. IOC or oil?
Oil.
Oil India Limited is represented by Sri M.K. Chaudhary, Ranjit Senior Counsel, assisted by Sri K. Kolita. First up, Sri S.C. Kyle, Leonard Counsel is present for the private respondent numbers 7 TO210. First up, Para. Pleadings are complete and the matter can be taken up for final disposal at the admission stage. First up, Para. As agreed to by the parties, by the learned counsel for the parties. First up, list for admission hearing on 21st of May, Tuesday.
The part heard point. All the records may be called for.
Have the records, Mr. Kolita? I have the records. Sri Kolita. Records of what?
Of the DPC.
Why? DPC
One
not
of
the.
in the
That is not
affidavit,
the subject matter, no, there is no dispute also in the DPC.
We have annexed the DPC.
but the marks are not given by the
How does it matter?
mark.
You're on the policy.
Fine.
Okay. Yes, next.
Deep knowledge.
May it please support. My lord, here, my lord, for the post of accounts, assistant accounts officer, my lord, under AEGCL, one advertisement issued on 14/8/2018.
Just a minute, please.
My
Advertisement for?
for the various posts, my lord, amongst other, my lord, post of assistant accounts officer, AAU, my lord, total 10 numbers of posts, my lord, for unreserved 4 numbers of posts out of 10. Well, I am an unreserved candidate, my lord. Now, my lord,
Advertisement was dated,
yes, ma'am. 14/8/2018.
the page,
Advertisement page, my lord, 12,
14/8/2018.
yeah, 18,
Yes.
my lord. Page 13 is the, my lord, numbers of posts, my lord. APGCL, my lord,
APGCL,
APGCL,
APG,
not AEGCL.
no, power generation,
APG,
power generation
Assam Power.
Generation Corporation
corporation
Limited.
limited. Respondent number 3 and 4 here.
Okay.
My lord.
Assistant Accounts Officer.
My lord. My lord, now, my lord, there is, in page 16, there is for each question, there will be 1 mark. And for negative mark, there shall be 2.25 marks. For negative wrong answer, negative mark, my lord. And my lord,
Each question,
yes,
0.25 minus 2.25.
yes,
0.25. For
negative.
wrong answer.
Wrong.
Okay.
My lord, page 21, for unreserved category candidate, the cutoff mark, they fixed, my lord, 56.25.
No. Huh?
APGCL, my lord, for cutoff mark,
Cut off for?
56.25.
For unreserved.
Unreserved,
56.25.
my lord. My lord, the petitioner appeared in the, my lord, written test, my lord. And also he was even called for the viva. Now, my lord, out of the total number 100 questions, page 48, these are the summary of the questions. Total 9 numbers of question, my lord.
Page?
Page 48, my lord.
Yes.
This is a summary he has given. My lord, from serial number 5 to 9,
they have assessed and their examiner has given the correct position of this question answer. And they say, my lord, serial number 5 is correct. Serial number 6 not correct. Serial number 7 correct. 8 correct. 9 correct, my lord. So out of 5, only 1 incorrect and 4 correct. In that view of the matter, out of these 5, my lord, 4 plus 1, because they have already deducted 0.25 in each question. My lord, if these 4 questions out of 5 are correct, then my lord, 4 plus 1 he will get. Now, so far 1 to 4 are concerned.
No, we have not understood, Mr. Das. How many questions are there?
Total 9 numbers of questions.
Only 9 questions.
Only 9 questions.
9 questions are in question.
No. These are the questions I challenge, my
Are
lord.
in dispute.
Okay.
These are the questions I challenge.
Okay. Nine questions are
Yes.
subject matter of challenge.
Yes.
9 questions. Subject matter of dispute. What has happened in 9?
Yes. My lord, so far serial number 1 to 4 are concerned.
Oh,
They
question.
say in the affidavit that these questions marks cannot be given because it will lead to modification of the select list.
No, what marks did you get?
Yes.
1 to 4?
1 to 4, they have not given any mark.
No negative also.
No negative, they had deducted, my lord, earlier.
1 to 4.
1 to 4.
That means 1 mark.
Yes.
Those are we said those are wrong. Question key and the questions are wrong. That is why nobody has
No
given-
marks. Okay.
No
1 to 4 was cancelled.
Can-
My
Okay,
lord,
okay.
that is
that
their
is- that is why
version.
if
Oh, no.
mark is
Let us hear his version.
I will show, my lord. I will.
So,
So, my lord,
question 1 to 4. You said that there was negative marking.
negative marking. 0.25 each 1 mark they have deducted.
Okay. Petitioner's submission. The order held to be wrong answers. Negative marks 0.25 into 4 is equal to 1 mark total.
Yes.
Deducted.
Yes.
And 5 to 9?
And my lord, so far 5 is concerned, the question, the examiner has said this is correct, but they have said that this is incorrect. And therefore 1.25 marks they have deducted.
Another 0.5.
Yes.
Petitioner intend to be correct, but to be incorrect. Minus 0.25.
0.25. Well, so
That
far
means
6
1.25 total.
Yes. Well, so far 6 is concerned, and they say this is wrong. I also don't challenge that this is wrong, my lord. Serial number 6. 7, 8, and 9, my lord. They say this is correct. So, 3.75 marks.
7, 8, and 9 are correct.
7, 8, and 9 are correct.
You get initially you were given as wrong.
Yes, wrong. 0.25 they deducted.
For each.
For each.
For 0.75 was deducted. That
Yes,
means
earlier.
0.7 to 10.
Yeah.
And held to be correct. To be correct. Correct. That means you get 3.
My lord. Now this time they have to give me, my lord, on this 7, 8, and 9, 3.75. Now my question is that, my lord,
Yes.
now my question is that, my lord, so far this serial number 1, 2, 3, and 4 are concerned. Well, I have given answer as per the answer set out by the authority. Lordship, kindly see. Page 37, my lord, of the writ petition. page 37, my lord. This is question and ID 10343. Down below, my lord.
No, you contended you had given correct answers. Okay. we
No,
have-
no, my lord. So for 1, 2, 3, and 4, they have not given me mark. My case is that
Yeah, okay.
these are correct answer. Because I have, for example, Losip, kindly see page 37, one of the question, my lord.
37.
37 page. my lord.
Yes.
This is down below my question ID 10343.
103.
343.
Page 37.
Page 37, my lord. Down.
Where? Question
Middle.
number?
10343.
10, where is
Question ID, my lord. It is written question ID.
question ID? 10.
340, my lord. Losip found, my lord.
10304 is there. 343, page 37.
Page 37. Top question is top of the, my lord, the page 10523.
Correct.
My lord, then next 10330, my lord.
Yes.
Then, my lord, 10350.
Yes.
Then, my lord, 10343.
Yes. Got it.
My lord.
Okay.
My lord, this answer given, my lord, one of the same question, answer given 10 and 15, and correct answer 10 and 15. Correct answer they put by them. My answer given, I have given the answer 10 and 15. And their correct answer as per them, my lord, 10 and 15. They have not given me mark here, my lord.
Okay.
Now, my lord, page 40. On the top of page. I have given, because my lord, as per their correct answer ki, I have given the answer.
Page now?
Page 40, my lord, 40. Question on the ID, my lord, 3045. From the top, my lord. Question ID 3045. From the top, my lord. Systematic
Page
sampling.
30?
Page 40, 40.
Oh,
my lord.
40.
My-
Okay. 40.
Yes. Question ID 10345.
345, yes.
Yes, systematic sampling. Well,
Yes.
answer given random sampling. Their correct answer ki malad random sampling. They have not given me marks here. Next question malad 42 malad. Page 42. 10338. 42 malad. From the middle lordship. Question ID 10338. The random number table, the distribution of the disease. Malad answer given normal distribution. And correct answer is normal distribution. Here also they have not given mark.
Okay,
Malad.
okay.
And page 47. 10337, Malad. Here also, Malad, answer given and correct answer. Same, Malad. So,
Just one minute. Yes.
So, my lord, my submission is that, my lord, except one question at serial number 6, question ID 10527. What they have assessed as not correct. I also admit that this is not correct. So, for serial number 6 of the my lord, summary, my lord, list of the questions I just from page 48.
No,
Question
that,
ID,
that you have,
yes,
these 4 questions.
yes,
Namely 10343.
yes.
10345, 10338, 10337.
My lord.
You said that you had given the answers which
Yes.
were held to be correct
As
by
per-
them as per the standard answer script, which they have not given you marks. You are entitled to 1 mark
No,
out of this 4.
out of 4, my lord, 4 plus 1.
One,
Because 1 mark is each correct answer. As per them, I have given wrong answer. As per them. So that is why they have not given mark.
okay.
So initially 0.25 in each of the
You
4.
said that it was deducted also. Marks were
Yes,
deducted.
yes, 1 mark deducted and
1
so
to 5 deducted from 4 questions, so 1 mark.
1 mark.
Otherwise, you are entitled to 1 each, so 4 plus 1 is 5.
Yes.
Okay.
Yes, ma'am. And my lord, now thing is that, my lord, page 20 is the, my lord, provisional merit list they publish.
Okay.
Page 20, my lord. Ten marks probably. Page 20, my lord, provisional merit list, my lord.
Page 20.
20. Yes.
That is the provisional merit list.
Yes, madam. And they have, since they have not given me these marks, I am entitled 10 at least. My lord, my merit position is at serial number 11. They given me 49 marks.
Page 20 is the provisional merit list.
Yes. Serial number 11, that is the petition, my lord.
13002155.
Yes, correct. Roll number.
Serial number 11.
My lord. Had I get this 10 marks, my lord, I would have scored
59.
Yes, 59. In that case, I would, my lord, serial number 4. I would have been placed at serial number 4, my lord. And this serial number 4, since cutoff mark is 56.25, since he scored that, therefore, one reserve candidate has, my lord, covered the place of unreserved category candidate. Serial number 4. My lord, now, my lord, they have filed one affidavit. In the affidavit, lordship, Biswajit Kaur, he has filed the affidavit, my lord. He is the Chief General Manager, HR. Because out of the 9 questions, 8 are correct. So far I am concerned. If 8 are correct, 8 plus 2, 10 marks I am entitled. And what they say, my lord, in their affidavit, my lord, I am only entitled 3.75. Now kindly see, my lord, their affidavit. Affidavit in opposition, my lord. Page 13. These are the question they, my lord, forwarded before the decided for re-evaluation, my lord, after my complaint. Page 13, my lord. Committee, one committee.
Affidavit by 1 and 2.
Yes. 1, 2, 3, and 4.
Paragraph?
My lord, page 13, my lord.
Para?
This is my annexure, my lord, I am
Okay.
referring to.
Of the affidavit.
Of the affidavit. After my complaint against this, my lord, questions, minor selection committee held, and my lord, they decided page 20 is the selection committee,
13 is the report on examination.
13 is the questions they decided to send it for my lord examination. Now see, my lordship, kindly see what is the report.
No, report is at page 13.
Yes, these are my lord, for remarks, clarification short for my lord.
Okay, okay. 13.
And next page, my lord, page 14.
Just a minute. Page 1414.
This is the Malat communication through email, yes, Malat, to Professor Shikhar Kumar Sharma.
Okay, doesn't matter. Yes.
Yes. Now he has given the Malat answer, page 15. Serial number 1, my lord, is in respect of question ID 10527. They have not given the question ID. It is in respect of 10527, question number 1. My lord, they say this is wrong. I also don't challenge this, my lord. This is wrong.
Which one?
Page 15.
For question 8.
Yes. Better, my lord, if lordship kindly note, my lord, question ID, my lord. It is in respect of 10527.
No, since it is not written.
Yes.
No, it's written as question number 8, isn't it? Yes.
8.
Okay, doesn't matter.
Yes. 8 question is from page 13, my lord. Oh no, it was a gondogol koriche. It was 10527 question ID. And next, my lord, for question 31st, the correct. My lord, the serial number 2 is correct. They have given. This is in respect question ID 10531.
Yes.
And then, my lord, number 3, painter is the correct. My lord, the question setter has informed this. Painter is the correct answer. This is also correct in respect of the ID number 10542. And then, my lord, 4 correct upward basis. My challenge was upheld in this question also. This is ID number 10324.
Okay, then what happened?
And then, my lord, serial number 5, my lord, ID number 10335. This is, my lord. This is also correct. Now, while saying correct, my lord, next page, my lord. This is communication to the pending council. They have enclosed, my lord. The question examiner has assessed only 5 questions, not the 9. And out of 5, he said 1 is wrong. And if 1 is wrong, then out of 5, 4 is correct. And if 4 is correct, 4.4 plus 1, 5, I am entitled. But what out of the 5 also, kindly see what they say?
No, out of 5 is 4 is correct and 1 is held to be wrong. That means 4 minus 0.25. It is 3.75.
My lord, in respect of other, my lord, already they have deducted, my lord. Already they have deducted 0.25. In respect of 5 questions, already they have deducted 0.25 each.
Okay, okay, yes.
So 0.251.
Oh, okay. For 4 questions, you are getting
Yes.
additionally getting 1 mark.
1 mark.
4 plus 1, 5.
Yes.
5 minus, okay.
So now, my lord, they say, therefore 3.75. They given, how from they have found, my lord, that the petitioner challenged 9 questions, which is the challenge of 3 questions, question ID so and so, correct. Therefore, they say only 3 are correct. Examiner has said 4 correct out of 5. They say 3 are correct. Question ID number 10531, 10335 and 10334 is correct. And therefore 3.75 marks to be given to him. The petitioner challenge question ID number 1042 and 10527 is wrong. But 10542 affidavit. Malot 1045 10542 Malot, so for that question is concerned, examiner said page 15, serial number 3, this is the question. One, Malot from page 15 again, Malot, after that page. Serial number 3, this is in respect of question ID 10542. The painter is the correct answer as claimed. So how they can say Malot here in the Malot forwarding letter 9/12/2021 page 16 that this 10542 is also wrong. I do not dispute that 10527 is wrong, but the question, Malot, examiner has after verification said this is correct. They cannot deduct, Malot, and they should give mark for this question also. And C is very important, page 16 from page regarding the petitioner's challenge for remaining 4 numbers of question. It is found that answer given by him and the answer key provided by the question etc. are both wrong. However, the marks for these 4 cannot be given as it would lead to modification of marks of all the candidates in the merit list. Malot, in my humble, this is wrong, Malot, because as per them, the question that I have shown, Malot, the answer key, this is their answer key. And from their answer key, my answer is correct. So therefore, they may not deny me this mark in respect of 4 questions. And so far, Malot, review or modifying the select, it does, in a given case, Malot, if on the basis of wrong question ID, marks are not given, then it is the candidate who will suffer, Malot. In such eventuality, even if there is a requirement for a modification, that may be allowed, Malot. And this is the judgment Rajesh Kumar and others versus Malot State of Bihar, 2013 4 SST 690. Here also, Malot, on the basis of wrong answer key, marks were not given. The Honorable Supreme
690.
Yes, Malot. Rajesh Kumar and others versus State of Bihar, Malot. Paragraph 15, 21 and 20.
16?
15, 21, 20. Here also, para 2 the model question given for the evaluation answer script can be appearing in the competitive as bound to lead to erroneous result and equally erroneous inter-stream merit list of the such candidate. Malot, this was the issue same. Now, para 15, Malot, this is for not making party. Even in this case, I file one IA for making party. The Honorable Court, Malot, has disposed of the IA by keeping 1 post vacant since 1 person has not joined. Now, Malot, 1 post is still vacant, Malot. Malot, para 21, Malot. There is considerable merit in the submission of Mr. Rao. It goes without saying that appellants were innocent parties who have not, in any manner, contributed to the preparation of an erroneous key or the distorted result. There is no mention of any fraud malpractice against the applicant who have served the state for nearly 7 years now. In the circumstances, while the interstate merit position may be relevant for the applicant, the outside of the latter need not to be an inevitable and exonerable consequence of such a re-evaluation. The re-evaluation process may additionally benefit those who have lost the hope of appointment on the basis of wrong and applied for evaluating the answer script. Such are those candidates as may be ultimately found to be eligible to issue appointment letters on the basis of the merit shall benefit, and such revision shall pick up their appointment on the basis and accordingly to their interest position on the merit list. In the result, we allow this appeal that is the order passed by the High Court and directed that answer script candidate A series examination held pursuant to advertisement be got reevaluated on the basis of correct he prepared on the report Dr. So and so. Made the body of this order and fresh merit list drawn upon that basis. Number 22.2 candidate who figured in the merit list but have not been appointed shall be offered appointed in their favor. Such candidate would earn their seniority from the date of appellants were first appointed in the accordance with their merit position, but without any backways or other benefits whatsoever. In the case of
Okay,
the
we have read this.
my lord, therefore, my submission is that, my lord, the affidavit what had been said, my lord, that may not be the correct. Now, I am entitled for the marks as per the correct answer key in respect of 8 questions, along with the negative marks they have deducted, except, my lord, question ID, my lord. Except question ID at serial number 610527. Except this 9, my lord. Out of this 9, except this question, I am entitled. The serial number 610527. My lord, one I was filed, my lord, for implement of those selected candidates. But in the I, my lord, those candidates appeared and said one candidate has already has not joined. And out of these 7 candidates, 2 have already been promoted. And therefore, the Honorable Court by order dated 7/9/2023 in IA number, my lord, 3453/2022, my lord, has kept 1 post vacant, my lord. One post of assistant accounts officer in Assam Power Generation Company Limited shall not be filled up until further orders till disposal of this writ petition. Hello, these are my oblige.
Okay.
Well, I want to prefer slight accommodation till in the affidavit in opposition some NHS are there, but in my copy those are not. Just I have got my
Your
got
affidavit.
those copies from my friend. Those are our affidavit. But I'll just go through and I'll just make my submission. I did.
Should have told it before. We are not keeping matters
Look,
half
look,
heard.
look. Take it. No point.
You are for whom?
For PN respondent was PN4.
APGCL.
AP.
Yes.
Lottery kindly comes the affidavit in opposition para 8.
Yes.
But Lottery has taken note of page 48.
Paragraph
Page-
8.
Page para 8 of our affidavit. Before that, kindly come to the writ petition for page 40.
Page
Page 40. Therefore, the petitioner has
indicated these are the question IDs, and he claimed that he should be given marks.
Yes, yes.
Just for a moment. So the 4, 1 to 4, those are wrong. And 5 to 9, out of 5 to 9, 6 is wrong. Now petitioner also admits that 6 is.
One to four wrong answers.
1 to 4 wrong. Well, in fact, there is difficulty. There is difficulty in the answer key. Well, and that is why mark could not be given. And
Means marks not given means was negative marks given.
negative mark.
Yes.
If even if it is not, if negative mark is it is deducted for some 0.25 mark is deducted, then out of this 4, you will get for 2.5 in one question into 4 is 1. That 1. You will.
If these questions, your contention is that if the questions itself were wrongly put, then the negative marks of 0.25 would be removed from the 4 questions, and therefore he gets back 1 mark.
1.
Okay, 1 mark. 1 mark. For 1 to 4.
For 1.
Okay.
Question number 5, I'm just going by his claim. Question number 5, he claims 1.25 means 2.5 mark, 0.25
0.25 for
deduction.
rejection, 1 for
He'll get
correct.
1. So he'll get 1. But if that is so, then for 4 questions, he will get 5.
No, question number 5 you are saying only.
Well, just
5 to 9 you are saying.
I'm going by.
5 to 9. 5
yes,
to 9.
5 to 9. 6 is wrong. 6 is wrong.
Oh.
6 is wrong. He also had.
5
6
to
is-
9. Question 5 to 9 except 6.
Yes, except 6. Then 5, 7, 8, and 9.
6.
He says.
Yes. 5, 7, 8, and 9. 1 plus 1, 4 plus 1. 5 marks.
Yes. 5.
5 marks.
5.
Yes.
But he has secured 49.
4 plus 0.25 into 4 is equal to 4 plus 1 is equal to 5. Okay.
5.
Okay.
He has secured 49.
Hmm.
The last candidate he has secured 56.25.
His petitioner's mark
Is 49.
49. Okay. Last unreserved
56.25. 56.
Oh, so he gets 54.
He gets 54. And this for these 4, if he gets 1, then he will get 55. So from serial number 1 to 4, he will get 1.
6. So
That will see.
59 plus 6. 49 plus 6. 55.
Yes.
Hmm.
Even then he doesn't. Although my affidavit standing in the affidavit is different, just from his claim, I'm just indicating that he will not come in any. If he gets 6, then he will be 55.
No, Mr. Das is trying to make out another additional case for him.
Look.
No dispute regarding 6.
6.
5 to 9 except 6. There is almost a consensus. 5 to 9 except 6.
All of this. He will get 3.75.
That is it.
We have said
Question number 5 to 9.
according to us, there are 2 wrong. He said there is 1. He admitted 1 wrong. We said there are 2 wrong.
How there is?
I in our affidavit, from my affidavit, we are saying.
No, Mr. Nath.
Look.
Just now what you have submitted.
Look.
So for question number 1 to 4, we will come to later.
Yes.
5 to 9 is concerned except 6.
Look, according to the petitioner,
He will get 5 marks.
He claims 5. He will
5
get-
marks.
If his case is accepted,
He gets 5 marks.
5.
And so far as 1 to 4 is concerned,
he will get 1.
you say that he should get 1
If
because there were negative marks given to him in 4 questions. Even if
Well,
those are held to be wrong, these negative markings will go, so he gets back 1 mark. His contention is that these questions which he had answered are the correct questions as per your question ID sample.
No, Malad, that I'll take your lot to my accept. Malad, so from this, Malad, he will maximum at base, Malad, he will get 6, and he will not come within the Malad, within the cutoff. But now, kindly come to our affidavit para I. In fact, there are 2 wrong. And therefore, we have given him.
Para 8 of your affidavit in
of our
opposition.
affidavit.
Okay.
This is an in fact affidavit in opposition filed by all the respondents, 1, 2, 3, and 4. It's a joint affidavit, and kindly come to para 8 first. The
Yes.
The second parameter, I'll just read. As per minutes of the meeting, the committee was of the decision to form a review committee to examine the relevant question paper set and answer key for the for the AAO exam received from the question setter in order to find out if it is in line with the response sheet. Further, the selection committee would obtain views from the question setter of AAO exam as well as APTEC Limited who conducted the examination and call for the clarification. Subsequently, the reviewing committee had submitted a report on 26/11/2019 after examining the question paper set and answer key for the AAO exam based on the objection raised by so-and-so is the petitioner. The committee in its report had mentioned to seek for clarification from both the question setter and APTEC Limited. Thereafter, by mail dated 5/1/2021, requested the setter, Professor Sushil Kumar Sharma, Professor and former Dean, Department of Information Technology, Guwahati University, to give his stand against the 9 questions raised by the writ petitioner. Accordingly, by mail dated so-and-so, it was informed to the APTCL that out of 9 question challenge, in the question number 1053531, 10335, 10334 of these so-and-so are found to be correct. 3 are found correct, according to us. Those are logic will find at serial number 531, 335, and 334, 7, 8, and 9 in the at page 48. If logic kindly open the page 48 of the writ petition.
Page 40.
Page 48 of the writ petition, where he has made his claim, initial claim.
The chart.
The chart. He has prepared. The petitioner has prepared the chart. These are 7, 8, and 9.
Five, 3, 1.
10531, 10335, 10334. These are found to be correct.
Yes.
And accordingly, the writ petitioner would be entitled to additional 3.75 marks. 3 marks for correct and 2.5 marks for the deduction bit again. And same would be given to him. As regards the question number 10542 and 10527, 10542 and 10527, lots will find in the chart, page 48, serial number 5 and 6. So according to Asmala, 6 is admitted. He also admits that it is wrong. He claims 5 to be correct. We said it is. We said it is. So he will not get this 1.2 according.
What is the basis of Mr. Das in saying that 5 is correct? One 10542.
Yes, Malad. That question in the Malad answers to page 34. Page 34, this is the question, Malad. It may be compared from here. From page 15, of the in the writ petition page 34, question ID 10542. Metal is related to sculptor. Huh? 10542.
105.
Yes.
No, we are not going into the
No,
merits.
that's correct, that's
merits,
correct.
But
Yes.
what did the expert say? Was it correct?
Expert, yes, he said correct, my lord.
Huh?
Serial number 3. Serial number 3 is the question, my lord.
Yes.
Painter is correct answer as claim. I claim as painter because my answer is page 34. I have given painter is the answer and correct answer also painter.
No.
Therefore, yes, page 34, question ID 10542. And this question in the affidavit page 15 also, my lord. Painter is the correct answer as claim. Since I have given the correct answer painter and their answer key as well as the expert opinion is the same. This is my basis, my lord.
That is his person. Now,
No,
just
no, this
now,
is there.
That is his person. I'm just making my submission. Kindly come to page 30.
34.
Page 34.
Yes.
Lordship, may kindly come to the question ID 10542.
34.
Yes, sir. 1054. Lordship,
10542. Yes.
I got to go. But kindly see, below, the options are given. Painting option ID 12166. Painting. It is painting. And an answer given by him is painter option ID. Answer given painter option ID 12168. 12168. And correct answer is painting option ID 12166. Correct answer is painting option ID 12166. The first option. He has given painter option ID 12166.
Okay. Your contention is that the right answer should be painting, not painter.
Well, this is possibly answer given is this, and the correct answer is this. This is as per the answer.
Okay. Correct answer should have been painting.
As per the answer,
He says painter,
he says painter.
but your expert says painter.
They have gone at the time of evaluation. They have gone by the answer. So there is a problem in the answer. That is what we have said in the affidavit.
Expert says painter, my lord.
That is what Lord, we have said it in the affidavit. But I did not get time just to tell you these annexures, because in my affidavit these annexures are not available in the morning. That is why just I have
Sure.
got for 5 minutes time.
Painting.
So they have stated.
But will painting be the correct answer?
Ultimately, no, I'm not an expert. No? That these are OMR sheets. They have to go by the whatever answer key is available with them. That by that.
But the question settler has said.
Whether lordship will interpret, whether the authorities have so wrongly deprived him, or they have followed the answer key. Ultimately, what?
No, on that you had sought the opinion of experts. You did not rest on that. Yes, we go by whatever is the answer key. Answer key says painting. He says painter. There's no need for going for an expert. You took expert's opinion. Expert says painter.
And next kindly see 10527. 10527. He also agrees.
Page.
He also agrees.
Page
10527. Page 35.
35.
Page 35.
10527. Yes.
7. Hard.
Yes. Filter water. Filter. Correct answer is sensor.
Correct answer is
Sensor.
sensor is to play.
Okay.
Sensor is to play option ID 12108.
This there is no problem here.
Then no problem.
No, no,
Okay.
he agrees.
Hmm.
He agrees.
Okay.
Well, even if the second answer is treated to be correct, then also he will get 1.25. Total comes to about 6. His total comes to 55. 49 plus 6, 55. Leaving the 4 questions. Well, coming back to the affidavit. Coming back to the affidavit. So, well, as regards the question ID number 10542 and 10527, the read petitioner's answer was found wrong, and therefore 0.50 marks would be deducted from the petitioner's total mark. The remaining 4 questions, it was found that the answer given by the read petitioner and the answer key provided by question setter are both found wrong. Those are in respect of 1, 2, 3, and 4. And accordingly, no additional mark has been given to the read petitioner, as the same would lead to modification of marks of all the candidates in the merit list. Therefore, no mark has been given to that.
So the controversy remains with the first 4 questions. First four question, he says that since I had given the same answer as the question setter, so I should be given 4 marks.
Yes.
But your contention is that you have held those 4 even key answers to be incorrect, so you have almost cancelled.
Yes, sir.
And even if you have deducted 0.25 for each of the questions, he can be entitled to at most 1 mark, 0.25 into 4. So he gets back 1 mark. So far as the other questions are concerned, one admittedly he has also said that question number 6 he is not entitled.
Yes.
And the answer of painting is concerned, you will go by the paper question answer which was given in the model question itself.
In the affidavit, they have said that we have treated to be wrong. Even if it is even if lordship considers it to be, then he will get 1 point. That will not make him to take up.
That means if the first 4, unless he gets 4, 4 plus 1, 5 in that, instead of 1, he will not make it.
One we have already considered.
That is.
One we have already considered.
Yes.
We have already counted 6. We have already counted. So in respect of the 5, my lord, the discrepancy, just I have to just tell him, my lord, just kindly give me 5 minutes.
So the painting may not come into the controversy. Even if we hold
As per
to
the
a
affidavit,
painter to be correct, then also he gets what? 1.25.
he'll get 1.
And 1.25, if you add 1.25, will he come in? No.
My lord, 6 marks we are calculating after giving marks in respect of question number 5, painting. If we deduct that, then he will get 3.75. It will again come less. If lordship holds page 48 for a moment.
48.
Page 48.
Yes.
But now we are proceeding.
So see this 1.25, it should be 0.25. Your projection.
Sure.
Question number 1.
Question number 1, 2, 3, and 4.
Oh, it should be 0.25 because you have cancelled.
Yes.
So this will be 0.25, 0.25,
Into 4.
0.25 and 0.25. This will be,
At base, it will be 1.
this he projected 1, 2, 3, 4, for he got, as per his calculation, he should get 5, you are saying 1.
1.
Okay. 1. And for question number 5?
5, we deny, he claims, if Lordship holds that, yes, he will get 1.5. 1.25.
1.25, okay.
1.2.
6 admits.
6, he admits that he will not
Oh.
get mark. No, correct. Then
Admits.
7, 8, 9, Manoj, according to us, it is correct. He will get.
Okay. 7, 8,
Nine.
9.
He will get.
So let
Six-
us see. 1,
3.75
2,
marks.
3, 3.75.
3.75.
Then 1, 4.75. Then even if we hold 5 to be correct, 4.75, 6 marks total.
6 marks.
6.
That is why.
6
Well,
total, he'll get how much now?
See, 49 plus 6, 55.
55.
55.
He does not make it.
No, 56.25 is the last.
Look, my only argument is that,
The painter, we give you full.
no, that's correct, Malad. So for the other, this
First four,
one-
the controversy will revolve around the first 4.
1 to 4, Malad.
Yes.
Because, Malad, the answer is set up by them, and the answer given by me is correct.
No, Mr.
No,
Das,
now till-
Mr. Das, Mr.
Yes,
Das.
yes.
We are not dispute or not
Yes.
even thinking anything else what we had submitted. We
Yes.
are going by you.
My-
But it is not a case that marks were deducted from you. They have cancelled those 4 questions. Because the answer given in the model answer is not correct.
Malad,
And
yes,
it's
Malad.
not a question of prejudice caused to you.
Malad, that
And
is-
whatever 0.25 was deducted has been given back to you. 1 mark has been given.
That was the Malad, instruction I specifically took at the time of preparation.
Yes.
Because kindly see, Malad, if they have not considered these questions and no marks given to the other candidates, then Malad, they could not have Malad deducted my 0.25 at that time of examination in respect of these 4. Number here, Malad, the problem arises. They have also not said. I
No,
think,
we,
Malad,
Mr.
yes,
Das, no, Mr.
yes.
Das will not go by that.
Yes.
Whether deduction done or not. Now they are saying that we give, if it was deducted, 0.25, you are entitled to 0.25. So 0.25 into 4 is 1. Now question arises is whether they have given marks or deducted marks for other candidates. What they have said on affidavit? Where
No,
have you said?
nothing they have said. And from that, Malad, I wanted to place.
On your
because-
affidavit, have you stated that for
they have
these
not-
questions, you have held, have given a similar treatment to all other candidates?
But that,
Malad,
that has not been stated. Ultimately,
This
in
is the-
respect of these 4, we have said that the stand taken is that.
No, your stand is, it
No
can be an,
no additional marketing
it
given.
can be an acceptable stand, it can be a reasonable stand, provided you treat all the competitors, aspirants at par. You cannot say, and he may have a point, that for a question which was cancelled altogether, you gave minus marks, which may indicate that you had given marks to some others, may. We are not saying you have.
In fact, Lord, our stand in the affidavit is that no additional mark means 1 mark, 0.25, what he is taking. 1 mark, that is not, we have not given, because that will lead to modification of mark. But before your lordship, Lord, just I'm submitting that even if because of some wrong, some 0.25 marks has been deducted from his total, then, my lord, if 1 is counted, my lord, even then he.
No, that we have accepted.
Yes, then
The question from this court is that whether for question numbers 1 to 4, you have given marks to anybody.
or whether then, my lord, whether from his thing, my lord, we have deducted.
Yes.
That is also not, my lord, shown. It is his claim that since you have given wrong answer, treated these 4 answers to
No,
be wrong.
see,
we
you
have
had,
deducted.
see, Mr. Nath, you have answered the writ petition
The one.
in the affidavit of position. You have not said that we have not deducted 0.25.
But our
Have you
stand is,
said?
our stand is about the remaining 4 questions. It was found that the answer key given by the petitioner, and the answer key provided by question setter both are found wrong. and accordingly, no additional mark has been given to the writ petitioner, as the same would lead to modification of marks of all the candidates in the merit.
That is,
That means-
that indicates something else.
No, that means, my lord,
That
means, my lord,
indicates something else.
that means, my lord, if we give him marks, then we have to give marks to the other candidates also. That means we have not given marks to anyone.
No,
that
you
is
have,
the indication, my lord.
that is not a direct answer.
That is,
That is not a direct answer. You did not revolve so much. Straight away said we have cancelled the questions. We neither
no,
deducted any
no,
marks
that-
from him.
not that.
Nor
that we have
that, so there is
that we have
no,
not
there is
said.
no question of giving
we have
any.
not. That we have not.
You file an affidavit.
No.
You file an
I
affidavit.
have- I have-
Only on this point.
Look,
Okay.
on 1, 2, 3.
1, 2, 3, 4. Yes. Rekha. The controversy raised in this writ petition is with regard to an evaluation in a recruitment process for filling up the post of Assistant Accounts Officer in the Assam Power, what do you call yourself, AP? Assam Power Generation
Corporation
Limited. Full stop. The petitioner, who is an unreserved category candidate, has made specific allegations of marks, of due marks not being given to him, and also on the aspect of grant of negative marks for answers which, according to the petitioner, is correct. Full stop. The petitioner has specifically mentioned 9 numbers of questions under the respective IDs. Page 48, ID second column to comma divided. ID number 1034, 10345, and again, page you can have. Full stop. As regards the first 4 questions, comma, the petitioner claims that though his answer was matching with the question setter, comma, he was given negative marks, resulting in deprivation of marks totaling to 4 plus 1 is equal to 5. Full stop. Regarding the question numbers 5, TO2, 9, comma, there is no controversy that the question number 6, that against question number 6, a wrong answer was given, and therefore the petitioner has concentrated his claim on the rest of the questions. Full stop. It is contended that in spite of giving right answers, comma, 0.25 marks were deducted from each of the questions, and therefore he is entitled to another additional marks of 4 plus 1 is equal to 5. Full stop. Para 3. D. Nath, the learned standing counsel of the respondent corporation, by referring to the affidavit in opposition filed on 22/2/2021, comma, more specifically, the averments made in paragraph 8, has contended that so far as question number 7, 8, and 9 are concerned, comma, the projection made by the petitioner appears to be correct, and therefore he would be entitled to 3.75 marks from those questions. Full stop. So far as question number 5 is concerned, comma, it is submitted that the answer given by the petitioner does not tally with the opinion taken by the expert. And even assuming that the contention of the petitioner is accepted, comma, the additional marks in that question would make the total to 5 marks. To 5 marks within bracket 3.75 plus 1.25 bracket says. The Learned Standing Council, however, has submitted that so far as the question numbers 1, 2 to 4 are concerned, comma, the model answer was found to be itself incorrect.
Can you keep just a minute time, just I'm indicating what has page 40.
Yes.
Page
Yes.
40.
Duster can Nice. Yes.
Page 48, logic, it is open.
Yes, yes.
But the wrong answer, where the wrong answer? The second question first I'm indicating 10345.
Yes, yes.
10345. What has happened? Kindly come to page 40. Page 40. For a moment.
10345.
10345.
At page 40.
At page
10345.
First,
Yes, yes, 3. Yes.
Well, these are the answers. Kindly see, well, answer given is random sampling. Option ID he has given 11377. Lot people find out at second option.
Yes.
Correct answer is random sampling, but the answer key says random sampling option ID 11379. It is mixed sampling. So the answer key was not correct. If let me he has chosen option ID 11377, then the computer will not consider it to be correct. Or random sampling, if he has given random sampling, he has given 11377 only, but the answer as per the answer key correct is 1137.
He has to write the answer or give the option.
OMR sheet, it is OMR sheet option, and then ultimately in the that particular thing he has to put.
Okay, we'll not put in such elaborate manner. You will find the affidavit. Oh.
So the problem is
okay.
the
Okay. Last week, you know. Are to are concerned, comma, concerned do no, I do not care. This court has, however, noticed that the explanation given so far as question numbers 1 to 4 are concerned, comma, those may not be adequate. We are not saying anything, okay, Mr. Nath? And therefore, an additional affidavit is required to explain in details the procedure adopted procedure adopted, which would include the marks given or any negative marks given to the petitioner, and also the treatment given to the other contenders in this, so far as these questions are concerned. These 4 questions are concerned. Full stop. Para. That such affidavit be filed within a period of 2 weeks from today. Para. Let this matter be listed within a period of 3 weeks from today. Let this matter be listed for further consideration on, we'll have a date after on 5th of June. Okay.
I'm referring to the one number part.
Okay. KP Pathak.
Nobody can be given mark because the key is indicating the something.
No.
And in the
See, Mr. Nath, towards the end of your argument, you had made a different projection. If that is so, he may not have a case. And if it is OMR, if random sampling the ID is different and random sampling the question, the what is that? Mixed sampling.
Yeah.
There is the IDs are not matching, then
It
it may
is-
be a different aspect. So you explain in details what has
It
happened.
is not, it is the case of the petitioner also that it is to be, the answer is to be given by ID.
No.
He submitted
No,
for-
no, you put,
Because
it-
of
you
the
put-
difference.
put your explanation that this is the answer, this is what you have put, this is why you have either cancelled the entire question or given 0.25 my deduction, and this is how we have treated the
Look.
other candidates.
Look.
That's all.
Yes.
Okay, second of this court, and of there is a tribunal.
Item 26, a date prediction.
He'll give dates. Any matter interim order till today? Yes, madam?
Please, Your
Yes.
Lordship, I beg to mention item number 31, Your Lordship, for correction of the year of the date of advertisement.
We'll
Oh,
have it
oh.
day after tomorrow. Day after tomorrow. Kuntu asat so? IA, you have filed IA?
The main matter is disposed of on 19/4.
Photo correction যদি করে দিও। Page?
First,
Page
page 4, Your
four,
Lordship.
in the order, which page? In the order of this court, which page?
Front page, first para.
First para, yes. First para, yes. An advertisement was issued when? 12/6 to 20,
12/6 to the advertisement date was 12/6/2018.
not 21.
And not
That is the only correction.
That is the only time.
Okay, এটা করে দিই। You inform Mr. Chaudhary, okay, he was there.
In para 4,
Yes. What is your name? T. Ramchari. T. Ramchari.
Yeah.
Heard MST Ramchari, Learned Counsel for the applicant, public writ petitioner, who by means of this application has prayed for a typographical error appearing in the first line of paragraph 4 in the order dated 19/4/2024, passed in the connected WPC 1206 of 2022. Full stop. It is submitted that the date of advertisement was recorded as 12/6/2021, which should have been 12/6/2014 or 18.
2018.
2018, full stop. The records of the writ petition has been examined. Full stop. The aforesaid date appears to be erroneously recorded as 12/6/2021, which should be 12/6/2018. Full stop. Para. Sri M.K. Chaudhary, London Senior Counsel. Please inform him. He was there.
Okay.
Senior Counsel does not object. Is his name recorded or not? Item number? And his name is not recorded.
It's recorded as-
He'll not have any objection. Okay. So, Para, in the interest of justice, comma, the aforesaid order dated 19/4/2024, passed in WPC so and so, stands corrected with a direction that the advertisement that in the first line of paragraph 4, comma, the date of advertisement should be read as 12/6/2018 instead of 12/6/2021. Full stop. Para. This order may be read as a part of the order dated 19/4/2024, by which WPC 1206 of 2022 was disposed of.
Deeply obliged.